issue
It is a part of my
the
affidavit.
second issue is under Article 25(2)(a), the state can make the law for the purpose of anything which is economic, business, political, etc., which is what this is. I'm sorry.
Yes.
If the claim is that it is a religious practice, the very scope of judicial review when religious practice is being asserted, because otherwise they will not have a 25 right, in which case they can't maintain under Article 32 petition. If they are maintaining the Article 25 claim, that very issue has been referred by 9 judges, of which
No, I am not.
No, I'm just saying.
Not be.
Just,
I am not supporting this argument.
That I know, but I'm saying that for an interim purpose, when this court itself has taken the view that these questions have to be referred, Shirur Mutt has been doubted, then that question will have to be decided first before interim orders are granted for a statute.
But item 11, my lord, apologies for not being there at the first one.
Fine. Milord, there is one matter, Milord. Mr. Nedumpara is present through VC. He wants to mention it, Milord. If Lordship may permit.
Mission is in the morning.
Item 24 on phrase sports knowledge. Item 24 on phrase, I have mentioned it 5 times sports knowledge. Got finally listed today. It's unlikely to be taken up today. Project may give it tomorrow or sometime next week.
What is that?
This is praying for damages. No? This can go in July.
I mean, it can wait after vacation.
For 2 years, they've been displaced from
After vacation.
after vacation. After vacation.
So we have to respond to the complaining.
I am for the he mentioned.
What's that?
Which matter?
4 items.
Can be. There are 200 tagged by us who have been cheated. Driving the ID relays IPC.
May I make myself? Well, let the petitioner start. We have got anticipatory bail. The intervener who suddenly come, Mr.
No, intervener. We are not really complaining.
But they are not the petitioner. Petitioners, Mr. Dama Srinath. Yes.
We'll have it in the next week.
Sure. Please.
Thank you.
Please. Oblige.
3 other accused are already on bail, my lordship.
Yes, who is for the state?
Lordship, I am for the state and I pray for minor 2 weeks for filing counter.
In that case, my lordship, I grant me interim bail, my lordship. Let them file.
No matter I'll submit.
16th of May.
My lordship, the difficulty is, my lordship has issued the notice on 20th of March, my lordship. In the last 20th of March, my lordship has issued notice. They did not turn up, my lordship. And last time, my lordship specifically directed them to appear, my lordship.
If I am
And
appearing
today
for the
again,
first time today.
petitions are there.
20th of March, the notice was issued. Why didn't you appear? So you were duly served.
And
Last week,
last
our
week,
name was not shown in the cause list. My
1 week by a plaster.
my lordship, grant me interim.
1 week by a plaster.
Lordship,
Why
please.
don't you listen up?
Much of the vacation is there. Vacations are there, my lordship.
The vacations, the court is working. It is only the lawyers who don't want to work.
Please.
The judges are willing to work.
Much of
Mr. Sibal is leading them.
Yes, we are together on that one.
Absolutely.
We are supporting each other on this.
9 lakhs, we have already on last more than 6 years, and salary not, just started. And who accused has been granted bail by the saloon,
Yes, who is for the state?
but they taken password in a month.
Well, item 9 and 10 are connected. Your Lordships have already granted bail to the co-accused on the ground that trial is live.
Yes, sir. The application is vehemently opposed by the learned counsel of the state, taking into consideration that the co-accused have been granted bail. Application is allowed.
And
Great.
9 and 10.
May it please, Your Lord.
In the NEET examination.
11 months in jail, charge sheet is filed, 200 witnesses to be examined. Lord, my name is not there in the FIR, nor in the first supplementary charge sheet. When, my Lord, even during that period, before the filing of the charge sheet, I was arrested. Now, my Lord, supplementary charge sheet is filed. And this is 511, my Lord, not an attempt.
Charge sheet has been filed, my lord, that's.
For ASG.
Lord.
I'm so blind.
That's all right. Mullahs, if your Lordships will remember that I made a very narrow argument, which was I looked at 4 or 5 sections, read the sections.
Yeah, because you have to prima facie convince us that it is so.
Yes, exactly. So I'm going to do that, Mullahs. And Mullahs, kindly just keep one thing in mind. A section cannot be read in the context of what is set out in the counter affidavit.
Yes.
Nor it can be read on the basis of what written submissions have been made. You have to see the section on its own terms, right, Mullahs? Therefore, let's see 3C, so that we just analyze the section. My learned friend said, all that 3C does is to change the revenue entry. It changes the revenue entry. I continue to be in occupation. I will not be evicted. I will not be evicted. I'll continue to be in occupation. And we don't determine any substantive right. The title remains with me. That's what he said. Now let's read 3C. Deals with only government property. Any government property identified or declared as Waqf property before or after the commencement of this Act shall not be deemed to be Waqf property. That's a declaration. If any question arises as to whether such property is government property, the state may, by notification, designate an officer above the rank of a collector who shall conduct an inquiry as per law and determine whether such property is a government property or not and submit his report to the state government. So he has to make a determination. What is the determination that he makes? That this is government property. Obvious, mother, from the plain language. So he has to first determine that it is government property. Then it says, provided that no such property shall be treated as Waqf property till the designated officer submits his report. So two propositions arise from there. Proposition number one, before he determines anything, before he inquires into anything, it shall not deem to be a Waqf. Under what principle of law can that be substantiated and upheld? Which principle of law? Before you start an inquiry, on the basis of any question that may arise, the question will arise in your mind or somebody files an application. And the moment that question arises, till such time as he submits a report, what report? That it is government property. Determine. It's not a Waqf. So under which principle of law can this be sustained? Not his counter affidavit, nor his written submissions, nor his saying title remains with me, possession remains with me, I cannot be evicted. Where did he get from the statute? It's not there in the statute. You have to read the statute. There are judgments of this court say, read the language of the statute and interpret the language. So point number one, the declaration that it's deemed to be treated as Waqf property till he submits his report without any basis because there is a question that has arisen is per se unconstitutional. Per se unconstitutional. And he has not answered that. And there is no time limit as to when he is to submit his report. So it will be treated as not as Waqf property, no time limit, no inquiry, it's before inquiry. That's point number one. Point number two.
That means it is after the inquiry starts.
Yes.
But prior to the report.
Yes. So he may take 6 months, he may take 1 year. So I have lost my right as a community has lost its right as a Waqf. If you don't, will you allow me, sir? I did not interrupt you for a minute. I request my learned friend not to do so. But that's, you sighed, let me say. And rightly so. So, that's the point. Point number two. What does he have to determine? That this is government property. As your lordship knows, the revenue entry will only be changed once you have determined your title. Can't be changed just like that. I am in possession. Take a normal suit. I am in possession in that property revenue entry is in somebody else's name, he'll have to file a suit. That look, I'm in wrongful possession. This property belongs to me. The revenue entry is mine. I don't have to go to court. He has to go to court. So, Madam, therefore, the determination that is government property is determined by him. None of this is pay me. It's behind my back. There is no procedure. So, the point number 2, there is no procedure established here as to how this determination is going to take place. Which law is going to be followed? Which is that procedure? Ex facie arbitrary. No procedure prescribed. He says inquiry as per law. What's the law? 83. So he has to go to court. Then why the designated officer? There is no other law. In this statute, Maharaj, other than 83, there is no other law. So as per law, if you interpret it to 83, he has to go to court before that determination. And other than that, there is no other procedure. Kindly see, it's very interesting. 83 says, if any aggrieved party, subsection 2, any mutawalli person interested in a waqf or any other person aggrieved by an order made under this act or rules, any other person aggrieved by an order made under this act or the rules may make an application within the time specified, and there also no such time is specified within such time as may be prescribed. This is the only mode. This is the only mode. There is no other law. And the expression law in subsection 2 is as vague as it can be because we don't know what that law is. Now the counter affidavit says, no, sir, but you will be heard. Very good. So now the counter affidavit will decide what that procedure will be. The statute will not. How does the title remain with me, Manoj? As he said, he's already determined. That's after he gives the report. I'm not. Before that, I've already made my submission. He's already determined that this is government property. Then only will the revenue entry be changed, Manoj, because it's sequential. After determination, in case the designated officer determines the property to be government property, he shall make necessary corrections. So the corrections can't be made till he determines it's government property. Therefore, Malaj, it's not just a revenue record change, which is the basis of his argument under 3C. Then how does he say? It's just a change of revenue records. And what's the explanation for this, Malaj? None. And it's irreversible, Malaj. Irreversible. The right of the community is taken away merely because there is a question that arises. Right, Malaj? And this particular section relates only to government property. I made these submissions, Malaj, earlier, not answered. Answered by the counter affidavit, but I say the title will remain his, possession will be his, he can't be evicted. Why? Who says that? Now, let's kindly 3C the definition of, in 3R, the proviso, which we've been reading. So now I've dealt with government property. Let's be dealing with something else, which is much worse. No, not user. No, I'm just saying something else. Kindly see. See, the Waqf means any person making such dedication.
So
the 3R proviso. May I read it? My notes, just MASIH. Provided that the existing Waqf by user properties, registered on or before the commencement of this Act of 2025 as Waqf by user, will remain as Waqf properties, except that the property wholly or in part is in dispute or is a government property. So if you take the government property, Waqf as user, that 3C will apply. And the same
People would apply
is government property.
while determination.
Sorry?
If the collector initiates process for determination,
Yes.
then only 3R would.
Yes, so it says, no? Except property wholly or in part in dispute or is a government property.
Somebody will have to claim that it is a government property.
That's correct. Who will claim? Not I.
The government.
Yes. And how will he claim? By going to the tribunal. Because I am occupying it. I take an example, one simple thing. Well, I am very simple. I have a burial ground. It's remained there for 200 years. There are so many burial grounds in this country, we're there for 200 years. Now, we don't know how it happened to be that, but burial is an essential part, is integral to the Islam, right? After 200 years, the government says, no, this is my property. Can burial grounds be taken over for?
But if you have registered, if you scheme the Act from 1923, on 1923, though technically you may be right that there was no provision for registration technically, but the information was required to be given to the authority. And then from 19...
Information to the court.
Whether we don't compete with that young...
Yes and no,
Then
absolutely
continuously from 1954, the registration is required, and that 1976 report also. Yes. We can read that report as to why registration was found to be.
I am at one.
It is not as if that from 1923 till 2025, over a period of 100 and odd years, if the scheme of various enactments has emphasized on a registration, and if somebody has not registered.
Correct. I must answer that. No? I'm going to answer it, and I have a full answer for it.
Because we believe in having an open dialogue.
Correct. I have a full answer because I knew that question will come from your lordship, but at the moment I'm reading the section, I'll answer that immediately. I'm reading the section at the moment, Mullah. It may not be 100 years old, it may be 3 years old.
3 years old, if it is registered, it will be protected.
But it may not be registered. Waqf by user may not be registered. I'm coming, there's a judgment of the Supreme Court, any number of judgments, Mullah, it need not be registered. That's settled law by the Supreme Court. Settled law. So I'll come to that later, but I know what is in your lordship's mind. That's why I'm not wasting too much time, just going straight to the point. Because I don't want to just dilly-dally.
We must tell you what is in our mind so that we can get the answer.
Absolutely. Now, Mullah, therefore, let's leave that out for a moment. Waqf by user of government property. Come to this, or in part is in dispute. It's a private person. If it is in dispute, Mullah, then how is it not Waqf? Government property is 3C. But is dispute...
There is no such procedure for any property with regard to private property, like 3C.
Yes.
So it's only 83 where the people, if somebody is disputing.
Yes. What will happen is, here the survey is not there now. I'm just giving your lordships an example. There's a private dispute, Waqf. Under the law, it's no longer a Waqf. But just by this expression is in dispute. At least, Mullah, in 3C, there's a determination that it is government property. There is no such determination here. There is no procedure of determination. There is no reference as to how this dispute is going to be determined. There is a declaration by law, by the legislature, that if there is any dispute, it shall not be waqf at all between two private parties. Under which law can this be sustained? Can't be.
Yes.
Now, Your Lordship, very important question. You also said, what is waqf by user? I'll give you a note because I'm going to answer that question. But Your Lordship has it?
Yeah, can we?
Yes.
Tables up, can we?
Yeah, I will just give it. No, one second. Now, just briefly, orally, I'll tell Your Lordships. In the 1954 Act, for the first time, they said these mutawallis are not the kind of persons who should be handling all this because they won't register. In the 23 Act. And then ultimately, it was decided that there should be a survey. And for the first time, that was decided in 1954. That we now must survey these properties to find out what is waqf and what is not. 54. Then came 1995. And in 1995, there was a whole procedure. Nothing had been done. That's not mutawalli. It's the states who were to survey, not the mutawalli.
That's what Mr. Rob also said, that his petition is pending from 19. That
No, but I'll show even more egregious because I'll give you data now. There are only 2 waqfs registered in Delhi.
Serious.
There is 0 waqf registered in Jammu Kashmir. But anyway, that's their data, not mine. But I just point that out as to why this happened. Why this has happened, I'm pointing out. In 1995, there was an elaborated procedure. Like, no, we must go and we must do it very quickly. Nothing done. No state government acted. Then in 2013, they said, okay, you guys have not acted since 1954. Now these surveys must be over in 1 year. I'm answering the question why they were not registered. The argument is they were not registered, so they lose their character as waqf. I am telling Your Lordships why they were not registered. The failure of the state government to not do their job from 1954 to 2025. And that failure, with that failure of the state government, the community is going to be punished because it was not registered. That's the argument. Now just read the note with me, Malat. It'll all be clear. Malat, kindly come to Roman 2. That's page 2 of the note. To justify the ouster of unregistered waqf by user from the protection of the Act. I'm sorry, Justice Messi has it. Yes. Page 2, Malat, on the left-hand side, Roman 2. To justify the ouster of unregistered waqf by user from the protection of the Act, the Union contends that there has been a consistently mandated legislative intent of registration for all waqf, including waqf by user, since 1923. Exactly what my Lord said to me. And that affording protection to unregistered waqf by user puts a premium on those who have been defying the law of the land since more than 100 years. This contention must be rejected. The statutory consequence of non-registration of waqfs under the Acts of 23, 54, 95, 2013 has never taken away the title of the waqf. Mandatory nature of the requirement to furnish details or register the waqf was limited to penalties being visible. This argument we've already made. Well, let's forget this argument for a while. Now come on. Statements of objects and reasons of the Mussalman Waqf Act 23 shows that the requirement of disclosure of waqf properties to the court was introduced because, in some cases, difficulties have arisen in finding out whether any particular properties are really subject to waqf or not. There are numerous waqf properties all over the country, unknown to the public, which the muttawallis are treating their own private property and dealing with in any way they think fit or necessary. Therefore, it is clear that the evil that the 23 Act sought to remedy was that of unscrupulous mutawallis evading public disclosure to escape accountability. This system was still dependent on the mutawallis voluntarily registering the waqfs. And therefore, the Waqf Act of 54 introduced, now this is the important thing, Section 4 and 5, which required the state to conduct a survey and register Waqf properties, thereby placing the onus on state governments to identify Waqf properties. This was continued in the Waqf Act of 1995. In addition, Waqf boards were given the power under Section 40 to identify Waqf properties which escaped survey, which has been abolished now. Section 40 goes. Now it's with the collector. Survey has been abolished. Well, just look at the egregious nature of this legislation. Despite this, it was noted in the statements of objects and reasons of the Waqf Act of 2013. There is no time limit fixed in the Act for completion of such surveys. So far, only one state has completed the survey. Well, this is the most important factual statement. In other words, from 1954 to 2013, only one state had completed the survey. Whose fault is it? Mutawallis. This is your legislation. And how does a person who is enjoying the benefit of the work find out whether it's Waqf property? What is this going on? So the community will be deprived because the surveys are not done by the state government. And now you will say because it's not registered, it's not a Waqf. This is, it's per se expropriatory.
Your responsibility is to register goals.
Back to my submissions. Kindly take volume 1 of the preliminary counter affidavit that the state government has filed. Just volume 1. Yeah, I'll come to that. I'll show that. Correct.
Yes. Page?
Page 158. There's a chart, your lordships have to turn it around. It says annexure R1.
158.
Yes, 158. Lordship has the chart? Yes. Just an idea, mothers. In state, for example, Telangana. We know, mothers, Telangana very well, mothers, as to how much how many members of the community live there. Number of properties registered in 2013, 0.
For registration.
0.
But nobody went for it.
If you don't mind, again, will you? I don't know why you are interfering. Why should you should not say all this? Worried.
Yeah.
So, well, therefore, 0. Who has not registered them? The survey commissioners. Not done their job. And now the 2025 Act says, we didn't do our job, so you've lost your right. That's the law. Is that reasonable? Isn't it per se unconstitutional? No, there are many such instances. Take, for example, Jammu Kashmir 1. Take Delhi Waqf Board 9. Percentage increase 1,153. Obviously, there will be, because you haven't done your job. Third from the bottom, Shia Central Waqf Board 0. In Uttar Pradesh, 0 Malaks. Imbabara, famous Imbabara, will go. Doesn't exist now. Malaks, just see the serious consequences of all this. And all this, my counter affidavit says this.
Must come in here, my lord. There
Please,
is,
please,
my learned friend is saying something fresh.
This,
Give me 1 minute. Give me 1 minute.
No, I'm
so
sorry.
that we will
I'm
not
sorry. I'm sorry.
taken
I'm
for
sorry.
a ride,
I'm
not
not-
unnecessary.
Even rejoined.
Yes, sir.
This is on Vamsi portal.
I'm coming.
Most of the boards
If you-
have not updated
I'm sorry.
figures in Vamsi portal.
Why are you interrupting him?
Please allow me to answer.
We did not permit them to.
I did not allow me, Wallace. Allow me. It's not fair. It's not fair at all. You make all kinds of statements and you say, we have misled the court. Every time, Wallace, every other half an hour, you would say, I'm sorry to say they misled the court.
But then there are also states where.
No, kindly see the second column.
So, Mehta, please, please control yourself. We are telling you time and again that don't try to compete with that young girl assisting Mr. Sibal and disturbing him.
I'm not saying no, but Malak, the question is, and see the last report.
No, but you see, there are states wherein,
therefore, there may be many more. Malak, I'm pointing.
Tamil Nadu is, Tamil Nadu, Punjab,
Maharashtra, 50,000.
Maharashtra.
Yeah, but there may be many more.
Kerala.
Malak, works are all over the state, all over the country. And those may be voluntary registrations. Because only one state had done. Kindly see the latest Vamsi report at page 63 of the rejoinder affidavit, or my rejoinder, 276 of 2025. I mean, this is shocking. And this is also 2013, Manoj, as of 2013. Sorry, I'm sorry. It is rejoinder affidavit 276 of 2025 deed matter, page 63. Because I need to finish because others have to speak.
No, so therefore we are not interrupting you much.
And you are not, Manoj. I'm just saying. I'm trying to be fast and not going to all the other issues.
We have to conclude.
You have been very kind, Manoj. Yes.
I think there has been least interruption from.
That's true. That is true.
Unless it was.
Well, we cannot blame you for that, Manoj.
Unless it was really necessary.
And then on this chart, they have themselves made submission at page 7 of the counter. They have themselves made this submission, saying that, look, our people did not work. We'll come back? Okay. We'll come back.
Yes. We can proceed and ask someone to find it out. So.
Okay. Okay, Manas. All right. While they find it. Now, Manas, kindly see.
We have to conclude.
Yes, before we'll conclude, Manas. No issue at all. Because now, Manas, kindly read one judgment of Justice Fazal Ali. Give me that judgment.
2 hours in the garden.
It's here.
What side we curtailed me not 2 hours in the garden?
Child list. Now, this is 1976 4 SCC, page 780.
1976?
1976 4 SCC 780, para 36 and 39. Yes. Now, kindly see. Yes, 36 and 39.
480, para 36 and 39. निकालें फोन में
Maybe it's really does cover.
At page 803, starts at 780 at 803, para 36. Page 603.
Yes. Amir
Ali in his book Mohammedan Law has given several instances of a complete and irrevocable dedication made by the Waqf for the founder and the consequences flowing from the same. Amir Ali observed as follows: the proprietary right of the Waqf is a building or ground set apart for prayers becomes extinguished either on the declaration of the Waqf that he has constituted is as a mosque or a musalla, or consecrated it for worship, or on the performance of prayers therein on thereon. Thus, the moment a building is set apart for offering prayers, the proprietary right of the Waqf is completely extinguished. Similarly, the following observations of the author indicate the various contingencies in which a dedication can be made to a public mosque. Kindly see, Mullahs, the second paragraph. When a mosque is erected, that one was. When a mosque is erected or set up inside a dwelling house or residence, and permission is granted to the public to come and pray, and a pathway is also made or set apart for their egress and ingress, the dedication is good by general consensus. If a pathway is not indicated in that case, according to Abu Hanifa, the dedication is not sufficient. But according to Abu Yusuf and Muhammad, it is good, and the pathway will be implied by the permission to pray, and this is correct. Now the last two paragraphs. If prayers are offered once in a mosque, it is difficult to constitute a good dedication. According to Qazi Khan, the delivery of possession as regards the masjid is complete when one person is prayed in it, and azan and his iqamat. The view universally adopted is that prayers offered by one person in a mosque is sufficient to constitute it as a public mosque devoted to the worship of God. For a mosque belongs to the deity, and there affixes to it a right of the Muslims in general, and one person can be a proxy for the establishment of the right of the Creator in the public. Therefore, if a person creates a mosque and gives permission to people to pray therein, it is an absolute waqf, and this opinion we adopt. Now, the observations of the learned author are based on Radul Mukhtar and other original religious books which contain law on the subject.
So no difficulty on this. Even the Privy Council, on which Mr. Dwivedi relied, also says that the land which was permitted by Hindu zamindar to be constructed for mosque, and by prescription, though there was no written document or something, but long user made it.
That's precisely the point, Mala. So long user will make it a waqf.
But if suppose on a government property.
No, government property also. I'll give you a logical example, but we have several examples. I can say so myself. What happens is that a community goes to the government and says, we need a burial ground. We need a burial ground. We don't have any. So, in fact, the government itself allots it. I know for a fact. And it is used for 100, 200 years. No limitation will apply to them. After 200 years, they'll say, no, this is our property. We'll build a commercial complex on it. What will happen? Because the moment it is used as a burial ground, it's a religious activity. In Noida. So the point is not that.
Everywhere, at every place.
Correct. And Mullah, these are not sometimes.
I don't think that the government is a.
Yes. No, it can be government, it may not be government.
Then in all such cases, I think most of them must have registered themselves as a.
No, but that is what they. No, these are not isolated. I'm talking about hundreds of properties all over the country. Nobody would know till you do a survey. And who is, I can't, supposing I'm a devotee. How will I know? I will not know. Nawazi will also not know.
Nawazi?
Namazi Mullah, he will also not know. He will also know he's offering prayer only. All the records are not with us. There are 39, para 39, read this, Mullah. It's very important. So, point is, you can't by legislative fiat just extinguish everything. 39. It would thus appear that in order to create a valid dedication of a public nature, the following conditions must be satisfied. That the founder must declare his intention to dedicate a property for the purpose of a mosque. No particular form of declaration is necessary. the declaration can be presumed from the conduct of the founder, either express or implied, that the founder must divest himself completely from the ownership of the property. The divestment can be inferred from the fact that he had delivered possession to the mutawalli or an imam of the mosque. Even if there is no actual delivery of possession, the mere fact that members of the Mohammedan public are permitted to offer prayers with azan and iqamat, the waqf is complete and irrevocable. And
that's what the Privy Council also.
Correct. So,
even the provisions of the law,
correct,
which have been taken to us, they also say that not only documents but other things other particulars could have been provided for registration.
And the point I'm making is, if I have used this now for 100 years, 200 years, 50 years, and this is my religious activity, then how can they take it back? Limitation has to apply also. There is no limitation that applies to them. They can take it at any point in time because they say this is my property under 3C.
Yes, we'll consider that.
Yes, so very, very serious consequences. Now, Malas. Now, I want to show the. I was in para 8 of the note. You also don't mind. Page 3, para 8. Despite this, it was noted in the statements of objects and reasons of the Waqf of 2013, there is no time limit fixed in the Act for completion of such surveys. So far, only one state has completed the survey. This survey was still not being carried out by some state governments, such as Gujarat and Uttarakhand. Even now, this is in 2025. So there is no Waqf in Gujarat and there is no Waqf in Uttarakhand. Is that the argument? And because it is not registered, they'll all be taken away by the government? Yes.
Please maintain your cool. If you want, we'll increase or decrease the temperature.
Then he says, it is therefore clear that non-registration of Waqf properties that have continued unregistered is partly on account of the unscrupulous mutawallis and more prominently on account of the failure of the state governments to conduct a survey as mandated by the Act, despite a lapse of 17 years since this mandatory obligation was imposed on state governments. Your Lordship asked me the question, I told you, but I have an answer to it. And this is the answer. This is a state responsibility by statute, which they accept they did not discharge. And then they say, because we did not discharge our responsibility, therefore, if it is not registered, you have no right. It's an unacceptable proposition of law. You can't take advantage of your own wrong through a legislative fiat. Then the argument that unregistered works by user can now be excluded. Unregistered Waqfs by user can now be excluded as over time of over 100 years to register Waqfs amounts to punishing the larger Muslim community, the beneficiaries of a Waqf, for its failure to the state government. Naturally, a number of Waqfs by user do not have appointed mutawallis, since the original instructions of the Waqf are no longer known. And hence, there would be no person who can be charged with the primary responsibility of registering the Waqf. It is also meaningless to argue that individual beneficiaries of a Waqf can also file an application for registration. Beneficiaries of the Waqf, such as namazis in a masjid or zareen, in a dargah, are merely visitors and will typically not be aware of the registration status of that place of worship. It cannot be saddled. Suddenly, they won't be able to go. It is for this reason that both times that a proposal was introduced to deny legal protection to Waqfs for failure to register, and the same was omitted on the opposition of the Muslim community. My learned friend made a point of that. Who opposed? Of course they would oppose. They were being punished for the state's wrong, Malaj. This is seen in the non-implementation of the proposed section 55E, Malaj, which he pointed out. Sought to be introduced in the Waqf Amendment Act of 84. This can be seen in a statement of objects and reasons of 95, which mentions the provisions of 84 Act could not be enforced because strong opposition to its various provisions came from the Muslim community. The second attempt to introduce such a provision was Bay of 87, which was omitted in 2013 due to the opposition. Finally, the contention of the union is based on a fundamental misunderstanding of Waqf by user. A Waqf by user is not a Waqf created by use of non-Waqf property as a Waqf. Waqf by user is a rule of evidence by which a Waqf whose documents on proof of dedication have been lost by passage of time proves that it is a Waqf. Depriving a Waqf by user status on account of its non-registration or making its status contingent on such registration is directly in the teeth of the Constitution bench. And so just read 1134 because I don't want to read it, no time. Our jurisprudence recognizes the principle of Waqf by user even absent an express deed of dedication or declaration. This is a Constitution bench judgment. How can the legislature go against that judgment and say there is going to be no Waqf by user because it's not registered? Whether or not properties are Waqf property by long use is a matter of evidence. The test is whether the property has been used for public religious worship by those professing Islamic faith. It's a burial ground or it's a mosque.
Oh, you are saying that there is a direct judgment which says that registration is not necessary.
Yes, there's the Constitution that I showed your lordships. W128 itself says so. 1134 says so. Doctrine of Waqf by user received judicial recognition. The decision of the Privy Council. Court of Wards of Property. This case concerned a public graveyard in Multan with a prominent Muslim saint was buried. Court of Wards acting with the property so-and-so proposed to sell certain property within the area. Muslim residents sought an injunction restraining proposed sale on the ground that entire graveyard was inalienable due to its long use as a public graveyard. Then 134 says evidence threshold is high. The most cases requiring evidence of public worship of the property is question of is since time immemorial. It was admitted that old mosque was, let's leave that out. So it is itself a rule of evidence. It can't be decided. A rule of evidence cannot be done away by a piece of legislation says we require no evidence. We will make a diktat that if you are not registered, you will not be a Waqf. Well, what basis do you say that?
Yes.
Then, Mullahs, now this takes care of Waqf by user. Mullahs. Now, have you got that? Have you got that file, please? The WAMC? Just put it. Right. Kindly come to 158. We have seen this already. Then, well, let's kindly come to page 63 of this rejoinder. It's a WAMC report itself. From 2013. Just see the middle, Malad.
Page 63.
Yes. Malad, this Rahman Khan was a member of the Rajya Sabha with me, and they worked for many, many years on this.
63
Middle of it says state UT Waqf boards where WAMC software have been successfully installed. Your Lordship has that?
Of rejoinder. Sir, I have your rejoinder 63 and some paragraph.
No, not rejoinder affidavit.
Rejoinder affidavit.
It's also there.
Rejoinder affidavit filed by Ejad Makbul.
No.
Rejoinder affidavit on behalf of petitioner.
That's correct.
Yes, that's what we have in response.
Mr. Arshad Madani, not this, please. Allow me. It's all circulate. Anyway, mother. See, state UT Waqf boards where WAMC, DMS software have been successfully installed are Assam. See that? Then digitation work. It is only installed. The software has only been installed. Now what does it say? Pre-digitization work is in progress. We are on 2013. Pre-digitization work is in progress. In all the state UT Waqf boards where CCF setup is under development or completed, once the pre-digitization work is completed in all respects, then an actual digitization work starts. That is, all the ownership establishing documents are scanned next using WAMC and finally imported into WAMC DMS at the present respective premises for searching and retrievals. The state UT Waqf boards where digitization is complete is only 4 in this country. In two UTs and Assam and Madhya Pradesh. The digitization work itself was not completed as of 2013. Only one state had conducted a survey and digitization state was completed in only 4. And now you say you did not register, therefore this is not what? This is not. Please, so therefore, Then you come back to the definition which I was reading once in that context. Because they say if it's government property and 3C, then you're out if it's not registered. This also goes into one of the final argument that he made, that all waqfs that have not been registered to FR are not waqfs. So if the whole process, if the registration depended on a process and the process is absent, then the outcome also can't be that the community loses its rights. Cannot be. So I've done with section 3 and I've done with the 3R provider.
3R provider.
Yes. Now kindly come with us to 3D. So that's all I have to say on these. Kindly come to 3D. Now let's two things on 3D. Point number 1. My learned friend rightly said that a part of 3D was discussed in the JPC, but rejected. Because when the bill came out from the JPC, 3D was not there. And the bill is annexed to the JPC. 994 in their preliminary, in their counter affidavit, page 994, the bill is appended. Yes, as part of the JPC report, volume 2, Malaj, 2A. To volume 2, Malaj. Yes, page 994. Internal page 828 of the JPC, but otherwise on top right hand side 994. Now at 996 clause 4, sorry, Malaj. I just finished. Give me 5 minutes more. Yeah, sure. 5 minutes more. Huh? I don't need 5-7 minutes more. That's all. Now 994 at 996. And if you see, Malaj, after section 3, that's clause 4 of the Principal Act, the following sections shall be inserted: 3A, 3B, 3C. That's it. No 3D. So the JPC rejected it. Didn't include 3D. Even though ASI proposed it, rejected it. That's the JPC's decision. Then it goes to Parliament. This is the proposal. This is the proposal, Malaj. This is the final bill. We are showing what the proposal was. This is the final bill, Malaj. That was the proposal what they showed. This is the final bill. And Malaj, what happened then? Went to Parliament. And then I showed to your lordships how it was introduced. The rule was suspended. It was introduced. So what was not proposed by the JPC was incorporated in the legislation without notice on the day of voting. That's what we told your lordships. Now, how is that, Malaj? Same for 3B, 3E, same for 3E. Tribal area, same for 3E. Now, my learned friend says, you know, what if there's a creditor who wants to recover property, recover property, then that Hindu will say, I give it to the Waqf. That's what he argued, Malaj. So if there is a Muslim creditor, Malaj, then he'll go to and tell a Hindu, you make a temple. So what kind of...
No such protection there. There's no such protection there.
No, but the liability will still continue. Only the land is gone. I don't understand what the argument is. How many creditors have come to this court and say they have donated it to the Waqf only to ensure that the money cannot be recovered? What kind of, is this an example that he is giving?
No, this is 1923 the SOR of the preamble. 1923 Act, which...
But there will be some instances where there will be instituted in every religion, but that's not the...
It is not his own argument. It is...
I agree. But that can't be the basis of interpreting a statute, Malaj. That may be, Malaj, an inquiry report, but you cannot...
No, but the SORs of the earlier acts, from which this act flows, can be read while interpreting the statute.
No. See, 3D, what... Just appreciate. What he's saying is the reason why this was incorporated in the statute because people.
Because of the discussion in JPC and because of the ASI making submissions before the JPC.
That's another matter, Manoj. That ASI issue is not. I'm not there, Manoj, at the moment. I'm not.
3D with regard to
Yes,
ASI.
correct. Now, Manoj, on the 3D issue, kindly read 3D with me now. Right, I'll finish in a few minutes. I'll just come once. Hold on, just give me finish. Says any declaration or notification issued under this act or under any previous act in respect of Waqf property shall be void. That's what 3D says. That's not what the Ancient Monuments Preservation Act says. That's not what the Ancient Monuments and Archaeological Sites and Remains Act says. They say the worship will continue. It's only for preservation. So how does it become void? What's the basis of this?
No, but your argument that it will not be permitted, the community would not be permitted to continue their religious practices, that is wrong because that is specifically saved by.
But this overrides that, Mullah, because it's now declared to be void. It ceases to be it says so, it is void. Moment it's a declaration either before or later. It says the declaration made or notification issued or under any previous act in respect of Waqf shall be void. Even under the previous act, Mullah.
No, even if the notification is issued under the
previous act, say 1904 act.
That act.
Yes.
Then the whatever is saved by that act would be applicable.
It can't be because this overrides. This is a later act which says it will be void. ASI is only to permit it to preserve. Yes, for permission. Yeah. Ownership is lost, Mullah. ASI cannot have title to the property. ASI may permit you to use.
ASI will have a control to protect the
That's right. So they are entitled to, Mullah. They are entitled to. But ownership is still with me. All I'm saying is, Mullah, ownership will still be with me. Under this ownership goes. And what's the rationale for that? There's no need for 3D. Because if that was the case, Mullah, that we continue to worship, there was no problem. So why did they introduce 3D?
No, because if you see the submissions of the JPC, before the JPC of ASI, that two parallel things were happening there.
You're right.
Those guides were, guides licenses were given by ASI. The Mutawallis of the Waqf, they are also parallelly giving license.
Correct. So therefore, that has to be stopped.
Not permitting them to carry out the preservation and
but that in other words, Mullah, if somebody building is unauthorizedly construction, something that is to be stopped, and there are regulatory measures to stop that. But it can't be, Mullah, that you take away my right, the property itself, ownership goes. There's no basis for that. Anyway, Mullah, because the time is short. Now, Mullah, just two, three broad points and then I've done with it.
Fortunately, we have vacation, but unfortunately, partially working. But unfortunately, we will have this for the okay.
Mullah, kindly have a look at this. Now, Mullah, I want to explain to you some fundamentals of Islam, Mullah. Some of them I learned from the other side, but some I'm trying to sort of understand myself. Now, Mullah, kindly see my note, paragraph 29. 27.
Spiral.
No, man. No. Today's no. Page 7. The union has argued that charity is prescribed by all religions, but is integral to none.
Paragraph?
That is paragraph 27 at page 7. The union has argued that charity is prescribed by all religions, but is integral to none. And Islam is not unique in this respect. This reveals a complete lack of understanding of Islam. It is well known that charity is one of the 5 fundamental tenets of Islam. Faith in Allah, the Prophet, and his messenger, namaz, roza, hajj, and zakat for charity. Zakat for charity. But what is this charity for? For the afterlife. because it's a dedication to God, unlike other charities. Further, the Waqf, which is nothing more than a form of continuing charity prescribed by the Prophet himself, is the only tangible means of continuing to accrue spiritual merit even after one's death. Right? It is integral to the religion.
That's integral to almost every religion charity.
No, but they are not charity to God. There's the difference. This is the only religion where you give it permanently. Once a waqf, always a waqf. To God. Dedication to God. No, unlike others. So my learned friend said charity is everywhere. But there's a difference here. Then two, even where waqfs are dedicated for purposes other, dedication is to God. Whereas charity is to the community. This is a dedication to God. Yeah. Yes.
Dedication to the
Yes,
God.
future, Malaj, future. For my spiritual Malaj's benefit. Otherwise, after life, once I have done this, I'll be treated better by Allah.
That's what, in Hindus, there is a concept like moksha.
That's right.
Moksha.
That's a Malaj. Moksha, of course, doesn't have. Para 29 members.
We are all striving all.
Yes.
Go to heaven.
That's right. That's true. That's right. Even where waqfs are dedicated for purposes other than places of worship, such as orphanages, hospitals, educational institutions, the sole purpose of the waqf is to please Allah. As such, waqfs cannot be segregated into secular and religious waqfs, as all waqfs are for spiritual benefit and nothing else. And this is part of my rejoinder, Malaj. And the property is vested in Allah. Property is vested in Allah, unlike others, Malaj. Then other religious endowments. Then the union has now, Malaj, last but one point, he says that now I concede that as far as Hindu endowments are concerned, they are for religious as well as secular purposes. He just said that this morning. Whereas throughout the tenor of the argument is the difference between Hindu endowments and here and waqfs is that's only for religious purposes and this is secular. Right? So now, Malaj, we are on par. So as far as Hindu endowments are concerned, no non-Hindu. But as far as waqfs are concerned, non-Hindus, non-Muslims. On what basis? If both are having both spiritual, religious and secular activities, both should be at par. And they reserve actually for non-Muslims. It's a reservation for non-Muslims. That's given in the statute.
So now you also agree that it is 4.
Yes.
From majority,
even one is too many, Malaj, according to me. Even one is too many. But anyway, be that as it may, Malaj. Now, why is this act not fully secular is explained by the act itself. Kindly come to the act. And kindly come to just one section. Section 96.
96.
I'm finishing. There's no time now, let the others do it. For the purpose, power of central government to regulate secular activities of Waqf. So obviously the act itself assumes that there are religious activities and there are secular activities. Otherwise the section would not be there. And what are those secular activities? To lay down general principles and policies of Waqf administration insofar as they relate to secular activities. To coordinate and function of the Central Waqf Council and the board insofar as they relate to their secular functions. To review administration of the secular activities generally and to suggest improvements. These are the secular activities. None else. And compare this with 32 minutes. The wide powers of the board. And the board is controlled by them now. Nominated by them. And there's no answer for the submission we made that the board was elected through electoral bodies and only Muslims. No answer to that. So why the change? because you nominate, so you are directly now trying to administer the Waqf. Now, Maharaj, having said that, just read 26 and then I've done with my friends will. Yes. In fact, Maharaj, on Waqf by user, Mr. Dwivedi had given a judgment. Just note the page at 20, it says, in the case of graveyard, it has been held in several cases that long user justifies the inference that the land itself is a dedicated or consecrated property.
That we have noted, that we have.
No, it itself says that long user would make it a dedicated property. And the next sentence says, or that even if it is not dedicated, it has become Waqf property. That's the judgment that he cited, which goes against him. Doesn't matter, I just point. Now kindly see 26 minutes and then I'm done. Now, there's a difference between 25 and 26. 25 says subject to public order. I'm sorry, the Constitution. That's the last point, my friends will deal with the others. Subject to public order, 25 was. Morality and health, and to other provisions of this part. Now, other provisions of this part is absent in 26. See 26 now. Subject to public order, morality and health, every religious denomination or any section thereof shall have the right to establish and maintain institutions for religious and charitable purposes. This act is for both for religious and not or. Religious and charitable purposes. We have the right to administer. They can't nominate people to manage its own affairs in matters of religion. So on secular activity, you can control us. But as far as religion is concerned, I have to manage my affairs. And rest of part 3 doesn't apply. And my learned friend cited D to administer such property in accordance with law. What law? Subject to public order, morality or health. That's the law. So, Malaj, it's clear, therefore, that 26 is an absolute right. Waqf is an integral part of our religion. I'm just making the point. I don't want to go to any judgments. And the public, and then the example I was taking about somebody giving away property because he wants to escape creditors was in respect of 3E, Malaj, not 3D. 3E. Because he said the tribals were, it's only in that context that he took that. That would apply to any community.
And deletion of 104.
Yes, and deletion of 104. So, Maharaj, what is now left is the collector will do everything. The council will be nominated by them according to us. From the statute, all majority can be non-Muslims. As far as the board is concerned, all of them have to be Muslims through an electoral college. That they've taken away, they nominate their own. So it's a direct violation of 26. Direct violation of 26. I deeply obliged to you. I'm sorry.
Thank you.
Yes, my learned friend will.
Here, since you can leave. Dr. Singh is here.
And I thought, pass that on. My Lord, I'll follow the learned solicitor's example of giving a note rather than referring to the judgments. I'll extract them. My Lord, I'm going to broadly answer the argument that was made at a later stage about essentiality. Let me just hand over this note. If I may, give me support on that. My Lord, I'll run through it very quickly because I have to hand over the baton, my Lord, to others. My Lord, Mr. Sibbal has already explained that charity is one of the 5 pillars of Islam. Now, my lord, if your lordships will see the Manusmriti, Dhan is mentioned, but religious endowments are not. The 18 titles, my lord. Now, this is important to the integrality and essentiality of Islam. It can't be compared with any other faith. It's the 5 pillars on the basis of which you dedicate property, it becomes irrevocable, and you win favor. In that sense, my lord, it's very different from moksha, as well from your lordships. Very different, my lord.
Like Mr. Mehta was saying that everybody wants to go to heaven without knowing whether such a heaven or hell exists or not.
Lord, my lord, some people call me an Arya Samaji Marxist. Now, in the Vedas, there were no temples at all. There was Agni, through whom you communicated to the gods. There was Indra, the goddess of rain, and my lord Surya. They worshipped, my lord, tanks, rivers, etc. So if you ask me, my lord, temples are not essential to Hinduism if you go back to the Vedas, my lord. Now, my lord, let me begin, my lord, on page 1 of my lord, the fact that it is essential and integral has never been in dispute. I begin, my lord, by quoting from the JPC itself, which they rely upon. Has your lordship got the first page, my lord? In inset 1.2, the concept of Waqf is rooted in Islamic law and traditions. It refers to an endowment made by a Muslim for charitable or religious purposes. This is the basis on which the JPC proceeded. It should be and, I'm sorry. Then, my lord, what the JPC does, I'll show your lordships, that part that it is devoted to God, etc., Mr. Sibbal has dealt with. 1.3. The word Waqf is not mentioned in the Quran, yet several Quranic verses, ayats, emphasize the importance of charity. And then, my lord, the surahs are given, my lord, in the JPC report itself. Then, my lord, 1.4, while the Holy Quran sets the foundation for charitable giving, the practice of Waqf is more directly derived from the hadiths. Over the page. So, my lord, this is essential. It is a part of the practice. The JBC didn't doubt it. I don't know why the Union of India now, my lord, doubts it. But let me proceed further. Paragraph 3, my lord, over the page. The counter itself proceeds on the assumption that the essential features of Islam remain untouched, and the amending act is only for regulation and improved efficiency. That's what they are claiming, my lord. I'll come to the significant. The nature of Waqf, it says, their counter, is sui generis and requires a suitable tailored approach. Then, my lord, very interesting, the counter also mentions cash Waqfs in the Middle East. Corporate Waqfs, Waqf Sukuk, my lord, Islamic bonds. But leave that, my lord. Now, my lord, counter on page 178 says, creating a Waqf endowment for religious and charitable is indeed a practice encouraged by Islam. This is their counter, my lord. Now, my lord, the next is, then they make an averment that charity in and itself cannot be made an essential part. This runs counter to their own counter, my lord, and the JPC. Now, my lords, kindly come to para 7, my lord. This is the Supreme Court, my lord, indicating what the nature of a Waqf is. Before we, para 7, it is for us to have a brief overview of the legislation affecting the institution. Waqf is an institution which is close to the heart of the Muslim community. There are various versions about its origins. I will skip that, my lord, because that's all. Then, my lord, para 71 on page 4. We may notice further statements contained in so-and-so. A Waqf is thus interwoven with the entire religious life and social economy of the Musliman. And this, my lord, is not a distinction between religion and charity. They're all parts of the pillar of Islam. So that particular argument was designed to disentitle us to Article 25 and 26. That's the sole purpose of the argument. That you show that it's essential, and otherwise the foundation of 25 and 26 disappears. Now, my lord, Waqf all others mentioned, I'll go over the page. I'm now, my lord, on page 5. Second para. As a matter of fact, the word sadaqah has a much larger meaning. My lord, page 5, top of the page, second para.
As a matter of fact.
That's sadaqah has a much larger meaning in the Muslim system. It means property speaking a pious act, a smile in a neighbor's face is sadaqah, to help the weary is sadaqah. Probably the only expression by which it can be construed is that the word charity in the broadest sense. Then, my lord, kindly come to the bottom of the page, page 5. It must be remembered also that a waqf is not a gratuitous transfer of property. It is a transfer to the legal ownership of the Almighty for substantial consideration. Then, my lord, waqf al. Now, my lord, I come to the term essentiality, which was used in Sirur Mat, 7 judges. And integral was added, my lord, in 2 judgments, Dargah Committee and Natwara. We're not concerned with that, but both are equally important, essential and integral. Now, my lord, kindly come to page 6. What does Sirur Mat say about this? My lord, the learned Attorney General, Mr. Sitalwad, my lord, made precisely the argument made on the other side. The learned Attorney General laid stress on 2A of this article, and its contention is that all secular activities which may be associated with the religion but do not constitute an essential part of it are amenable to state regulation. That is their argument. It was rejected. The contention formulated in such broad terms cannot, we think, be supported. In the first place, what constitutes an essential part of a religion is primarily to be ascertained with reference to the doctrines of the religion itself. They don't decide it, my lord. I'll come to a passage in Ratilal on that. Now, my lord, comes to the last 5 lines.
Of this very page.
This very page. Or the use of marketable commodities would not make them secular objects. Partaking of a commercial or economic character, all of them are religious practices and should be regarded as religion as such. My lord, Mr. Sybil, the argument was enough, my lord, on arbitrariness and irreversibility. They've raised the argument, so I have to answer it, my lord. Taking the very foundation of Article 25 and particularly 26, they say it doesn't exist in your case. Now, my lord, come over the page. My lord, Mr. Sybil read Article 26, A and B, and then D. Now, unlike 25, it says public order, health, or morality. That is the only ground, my lord, for interference. There is no other ground, my lord, in Article 26. 26 constitutes the institutional rights of a denomination. The 25, my lord, is to profess, practice, propagate. 26 is the institutional rights, and we are concerned on this side with the institutional rights of the denomination of Waqf. Now, my lord, on page 7, my lord, it distinguishes between 26B and 26D. And I will, my lord, read out that portion, 5 lines from the top. The administration of its property by a religious denomination has been placed on a different footing from the right to manage its own affairs in matters of religion. The latter is a fundamental right which no legislature can take away. They don't have that right, my lord, to take away my 26B function. That is my administrative function. It's an institutional function given to me by the Constitution. Then, my lord, I come to the second part, just below the middle page. It says, and the law must, the indented portion, not underlined, therefore must leave the right to administration to the religious denomination itself, subject to such restrictions and regulations. Now, my lord, in Cyril Mart, my lord, 8 provisions were struck down. I won't go into them, they are listed there, my lord. And some of them, my lord, relate to religious as well as secular activities. Your lordships will see that on page 8. Take, for example, on the power, that's about the third dot, on the power of commissioner to appoint a manager for secular affairs. Struck down. Notification of religious incidents, especially without access to court, as Mr. Sibbal argued, on the basis of a notification, struck down. Power of the commissioner to add or alter a budget, struck down. Now, my lord, Rati Lal, my lord, I'm on page 8, my lord, para 12. The indented portion. The right of management given to a religious body is a guaranteed fundamental right which no legislature can take away, including non-Muslim. My lord, a non-Muslim, according to Puttaswamy, exercises, my lord, his choice. In 25, I exercise my choice. I want to contribute, I don't want to contribute, it's up to me. How can you take that choice away from me? Now, my lord, come over the page. I come to page 9, para 13. Religious performances or acts of performance and religious beliefs are as much a part of the faith or belief in particular doctrines. No outside authority, kindly note that, neither the Union of India nor the solicitor, no outside authority has any right to say, important, my lord, he said it, my lord, not the Union of India, my lord, otherwise, not the JPC. No outside authority has any right to say that these are not essential parts of a religion. And it is not open to a secular authority of the state to restrict or prohibit them in any manner they like under the guise of administering the trust estate. Who says that, my lord? Can they say it? Now, this is a 5-judge constitution bench, my lord, which has never been diluted. Then, my lord, the doctrine on charity, my lord, which is 2 proviso. In Rati Lal, they said the charity commissioners cannot even appoint the manager as far as religious endowments are concerned. So, my lord, they've argued section 2 proviso, my lord. I have a choice, my lord. If I want to do it in the form of a trust, I will put it in the form of a trust. If I want to put it in the form, my lord, of a waqif making a statement, that will be so. If it's worked by user, my lord, it's accepted. So, my lord, trust is not trust is one vehicle, my lord. And you can't eliminate it. They say it cannot be done anymore. That is irreversible, my lord. My right, my lord, to formulate a trust which is there recognized by Rati Lal is taken away. Now, my lord, what really happens in this, my lord? What is our objection? Our objection is, my lord, you have liquidated the extent of the doctrine of Waqf. You have liquidated it irrevocably. And that, my lord, your lordships will find, my lord, at the top of page 10. Waqf by user under 2R sub 1 has been abolished. It's gone. It no longer exists, my lord, despite what the Babri Masjid judgment says. So, my lord, the basic concept of Waqf property eliminated. Now we come to the second. Ancient monuments prop 3D, my learned friend has argued it, it shall cease to be Waqf retroactively. Never existed before, my lord. Eliminated from the concept of Waqf and Waqf property. Now, my lord, this question of scheduled area and the 5th and 6th schedule. The learned solicitor argued that this is a constitutional classification. The constitutional classification, my lord, is regards areas. There are 4, my lord, states that are covered by the 6th schedule. And as your lordships are aware, my lord, the 5th schedule covers areas across India. That is the constitutional classification. Now, can you say to a Muslim within that area that he cannot create a waqf? It disappears, my lord. And this is our objection, my lord. You have fundamentally altered the law of waqf prospectively and retrospectively. And if the act comes into effect, what happens, my lord? All this is gone. Then, my lord, the next one. Waqf in the form of trust, I've already argued. That's my choice. You have eliminated it. Ratilal says it's permissible, you eliminate it. The next, my lord, is evacuee property. My lord, as Mr. Sibal argued, my lord, this is a gift of partition. The evacuee properties, my lord, vested in the board. Because you couldn't find out, my lord, who the Waqif was, they had gone to Pakistan. Now what happens now, my lord? That area is now eliminated from the concept of Waqf and Waqf property. Apart from the arbitrariness, my lord, what does this act do? It eliminates the very concept of Waqf and Waqf property. And this will take effect immediately. Then, my lord, come to the next, the non-Muslim I've dealt with. And now it says, my lord, that the Waqf will have an overriding effect. What does this mean, my lord? That the places of worship act, my lord, on which orders have been passed by your lordship, will disappear, my lord. Your parliament has protected these areas. They will just disappear. So, my lord, this regulation in the name of management, my lord, is nothing more than
provision is omitted.
Yes, I understand. As fundamental, do you want to interrupt again or shall I continue?
No, please continue.
Oh, thank you. Yes. I do need your permission from time to time. You are a past master at this interruption, my lord. Now, my lord, kindly come. Now, my lord, one person, my lord, and I have, my lord, Muslim clients. They say we are in a scheduled area. We follow Islam. Whatever traditions may exist, I am not deprived. Now, in all the scheduled areas, my lord, the 2001 and 2012 census, my lord, I don't have those reports just now, indicated the extent of Muslims in the scheduled areas. Enormous, not like Lakshadweep, my lord. Now we're talking of 5th scheduled areas as well. What happens to them, my lord? They're all over the country. Okay, I'll just finish.
You can't control your junior.
No, me. My lord, he's leading our team. Whatever he says, I go by. So, my lord, I invoke the doctrine of direct and inevitable effect in Maneka Gandhi. What is the direct and inevitable effect of this legislation? It deletes altogether. Then, my lord, 300A is applicable, my lord, because once my property goes into limbo, not acquired, I lose it. Then, my lord, constitution, last point, my lord, and the rest, my lord, your lordship. My lord, the new kid on the block, my lord, according to your lordships, is proportionality. It means, my lord, in a constitution bench judgment, and footnote 70 of Justice Khanna's Kejriwal judgment, the least invasive approach. Now, what is the least invasive approach if you want to regulate management and to prevent mismanagement? Is it to destroy the very concept of Waqf? No, that is the broad argument, my lord, I will place before your lordships. And I would leave it at that. I'm very deeply obliged.
Please do, my lord.
My lord, as far as stay is concerned, my lord,
Point formal, as pointed because our lordship has seen enough of this case. First, I heard Mr. Mehta say time and again, the law granted it and the law took it away. It's like the biblical dictum, the Lord granteth, the law takes away. Unfortunately, laws can't act like the Lord. Well, it's the sentence that Waqf by user, the law granted, the law took away, is the fundamental fallacy on concept. Your lordship's basic jurisprudence is that legislation does not create Waqf by user. Cannot. It recognizes Waqf by user. So the very fundamental point conceptually is wrong because you recognize, you don't create by legislation, there's nothing to take away because you are not the creator. Related to this, balance, this recognition of an essential Islamic concept is not by legislation, but part of the corpus, balance, is itself recognized in para 1134.
That is what even Mr. Dwivedi also has.
Yes, I'm on that repeated thing that what the law gave, law can take away. I'm now on 2R. That's the context in which Mr. Mehta made that point. I'm not, Mr. Dwivedi may have got it right, contrary to Mr. Mehta. I'm disputing Mr. Mehta. Number two. So therefore, there is no question of taking away something which you never gave. And the paragraph is 1134 of Ram Janmabhoomi Law, should be seen in the other context, but 1134. Number two, this registration is an important, it's actually a connected aspect. Now, registration did exist earlier. That's not the point at all. The point is, whether the arc you have created in this new act of taking away the status of an entity in the absence of registration existed anywhere. That is where, with great respect, the Union of India is not quite correct. In fact, grossly wrong. Registration was there. It required mostly petty penalties, later on 3 months and then 6 months imprisonment. Now, the point I'm making is that there is, just see 36.1, or very quickly. 36.1 I should have seen many times. But 36.1 says that every Waqf, whether before or after, shall be registered. There's a connecting arc here which I want to emphasize, which is in a different facet. So 36.1 every Waqf, whether created before or after the commencement, shall be registered. Before or after. So in perpetuity before and always after. Now, since first of all, I'm just giving a point form because this connects very interestingly to 36.7.10 and to surveys. That's the connection I want to make. This is a vicious circle. This draft, this act, makes a vicious circle complete and impossible of compliance. Now 36.1 says any time before in the hoary past, now and continuing. Now Waqf by user has been abolished by the same thing, the same act in 2R. So Waqf by user having been abolished can't be registered. Your lordships can't have a registration of what the same act abolishes. The same act abolishes it. Then we go further. So one is everything should be registered. Second is I abolished one category, so you can't register it. Third, then becomes a impossibility of compliance arc in 36.7a and 10, which give your lordship 3 months and 10 months for something you can't comply. It's an amazing structure.
Sorry, I didn't get it.
Yes, this is important. So this facet I want to emphasize has not been put like this before. The original thing says anytime created or anytime later there must be registration. In the same breath it says Waqf by users abolished. 2R, not we seen that deletion. You can't register something which is abolished, fellas.
Why? If you read it harmoniously,
no,
you
the
can't
abolished,
see the provision of a statute in isolation.
No, what is abolished can't be. What they've given is a saving proviso, which I'll come to. They've given a saving where they put a caveat of dispute. I'm coming to that. Malas, per se in concept.
Can't it be read in such a manner? If you read 3R reading.
Therefore, I'll just come.
Harmoniously.
I will.
That even in case of the works which are the works which are
3R
which are not registered.
3R
given a breather of a particular period.
3R tries
given earlier.
3R tries to give a saving,
was given earlier
which I'm coming to.
as a last window.
3R does give some saving, whereas I'm saying something else. I'm developing it. 36(1), having told your lordship this, then says that do something in X months or Y months under 7A, 8 and 10. Now turn to 7A. So 7A is the starting of that process, receive an application and do XYZ. My lord has got, sorry, 7, not 7A, 7. My lord has got 7. 7 is receive the application. Now come to 7A. He mentioned that this is government property. The same registration with 36(1) requires shall be stopped. Well, the collector has to mention, allege, think, state. 7A will stop the entire process of 36(1). By whom? Not by a court, not by a tribunal, by a collector. And the previous page says it is mandatory. You must register. Now come to 10. My learned friend says that this is similar to Provision in Trust Act, etc. Not at all. I don't know whether my learned friend should or should the Bombay Trust Act that provision. It's a 2-line provision. Now, no resemblance to 3610. 3610 says that you cannot register after 6 months. By the way, this 6 months expires in November 2025. November 2025, the 6 months expires.
Prospective.
You cannot, sir, that's not Mr. Mehta's on-the-spot benevolence will not rewrite the statute.
No, November 2025.
He can have all kinds of, he can have all kinds of savings of his own.
No.
But that saving will not rewrite the statute.
That's the only way.
Now, very well, how it will be read will be by the court, not by you and me.
From where do we get November 25?
6 months? Says so much. Now, one more sentence, the arc is complete. With this, my learned friend's counter says, you can't register now because we never found you the survey. We did surveys, you did not register, now you can't register. And then the last point, Mr. Sibbal said something which was disputed. Now let me show Mr. Mehta's admission. Turn to his counter, page 258. This is a bizarre situation. It's like chasing your tail. It's worse than chasing your tail. Please take give the counter, sir. 258. Time is limited. Please give the counter. 201. This is an admission, even assuming Mr. Sibbal is wrong. I'm not saying he's wrong. This is an admission of Mr. Mehta. Just see.
Page 2.
258. And look at the clever language also he tries to use in the middle of that one.
Page
258 of the counter.
Counter.
Whereas admission has been called by the Privy Council as the highest degree of proof. You don't need to prove something which is admitted. I must kindly mark my 5 elements because they make a connecting arc. 36(1) registration. 36(7)(a) you cannot register.
36.
Well, let's just mark my arc. 36(1) everything must be registered. Shall, etc. Very clear. By this act, we're talking of this act now. 36(7)(a) collector has to allege one line. Everything stops. Forget 7. 7A only. 7A only. And use the word dispute. not a conviction, not an adjudicated dispute, not a decree, not an appeal, nothing. Collectors one sentence, this is in dispute, I believe. Well, actually what they say is, I believe this is government property. Now 36(7)(a) stops 36(1). Then goes further, 36(10) says that you can't challenge this because you're not registered in 6 months. Now, this is amazing. Kindly read it. After, no can be commenced, etc., etc., the last 2 lines, by any court after expiry of a period of 6 months from the commencement. That is November 25. Now, Mr. Mehta may say, read it like this or that. The statute doesn't read it like that. The statute is harsher than the kindness of Mr. Mehta. That's all I can say.
I read
I
the
wish
way
he
it
was
is
the.
written.
I wish he was the controller of all the Waqfs in this country. His interpretation may be more benevolent. I don't know. I can't take that chance, fellows. Either your lordship interprets it, or the legislature writes it. Now see Mr. Mehta's admission at 258.
Mr. Mehta is never.
So the
58 is JPC report.
No, I mean Mr. Mehta. When I say
admit or deny,
JPC Mehta, we are sufficiently experienced to know that when you say Mr.
Yes,
Mehta,
yes,
it does mean Mr. Mehta.
He has much better thing to do.
Now, Willis, he quotes the JPC report, his counter, and accepts that surveys is a farce. Just note down, there are, Willis, as per him, 5 out of 28 states. Just note the figures first, then I should read it. 5 out of 28 states where there is survey. 5 out of 28 and 4 out of 8 union territories. Note these 2 figures once. The chart is given at 259 of Mr. Mehta's counter affidavit. 5 out of 28 states and 4 out of 8 union territories, and 9% of the total area of this country is represented in these 2 figures. Now let's just look at this vicious circle of the 5 elements. 36(1), 36(7)(a), 36(10), and the survey. It's an impossibility, Willis. It's worse than chasing a tail. Now, in his favor, which he is not argued, or he's not even today he's perhaps resisting, let me say something in his favor, Willis. 3R makes a very clumsy attempt to Mullahs. No, not 3R. 3R. The proviso. 3R, the proviso, makes Mullahs a somewhat clumsy attempt to save something, but puts the caveat of a dispute. Turn to 3R proviso. Let's turn to proviso. That is the harmony, my lords.
By now, we remember 3R, 3D.
Proviso. No, I was the proviso. I'm not on the main 3R.
Proviso.
Correct. My lordship had those 3 days full. It's come. Well, it's this proviso puts the same caveat of a dispute. Dispute is alleged. Then there's no, I can understand a decree. I can understand a primary adjudication. So whatever is attempted to be supposedly a partial saving is taken away. The caveat takes away everything else. Next point, Willis. Next point.
What is the meaning of easy and dispute?
There are, Willis, we filed a joint written submission, Mr. Sidbala and others, Willis. Just take the spiral for a minute. Take half a minute only. Give the spiral, madam.
The spiral.
The next point.
Okay.
At page 8 of this spiral, I'm sorry, page 6 of this spiral, I have cited the proposition on top in small Roman 4, page 6. I just, to save your lordship, noting down or writing, page 6. Apart from Ram Janmabhoomi judgment, apart from Siddiq, that has been cited many times. We had put in our submission, which is incorporated in the mega submissions, small Roman 4. Additionally, and this has been your lordship's one-way consistent interpretation across India, consistently held by high courts, that the absence of registration does not affect the original character or status of a property as well. Now, Willis,
where are you reading?
At page 6, small Roman 4.
Okay.
2-line proposition. There are 4 cases from Karnataka, Kerala, Allahabad, and Willis, one more, Andhra, in the footnote, if my lord may just be assisted by noting the paras are not there. I've checked with the paras, just note down the bottom of that, if your lordship doesn't mind. The first one is Allahabad, para 7 to 9. My apologies, or I can have it put to the court master. I don't, just very quickly, para 7 to 9. Karnataka is para 3 bracket 1.
In the footnote.
Footnote
So you have seen that.
Kerala is para 2 and 3, and Andhra Pradesh is para 20. These paras are not there, that's the fault. Can I repeat it very quickly and slowly?
Yes, please repeat the para.
Yes. The first is Allahabad, para 7 to 9. What is written as AHC, that's Allahabad, 7 to 9. The second is Karnataka, para 3-1.
31.
3 bracket 1. Then was Kerala, paras 2 and 3, and Andhra, para 20.
Kerala, after Kerala, what is it?
Para 2-0.
So after Kerala?
Andhra, the last one. Andhra, para 20. All that we don't have time to argue that you can't remove the reverse the judgment, you have to remove the basis. This is all just follow the blanket approach. Now, very quickly, your lordship sit for 5 minutes extra, your lordship doesn't mind. I'll be very quick.
Yes.
Now, the other second.
Let's have 10 minutes extra with the lunch. Lunch recess, we are sat for 10 more minutes. So we'll
that's
sit
not
for
the
10
reason
more.
I'm saying so. That's not the reason I'm saying so.
That's
not at all the reason.
Parity.
You were very generous with the time with us. Your lordship sat.
Parity.
No, that's not the reason I said. Now, my learned friend.
Yes.
My learned
In
friend.
fact, Manoj, both of them curtail.
Don't curtail his time.
That's the problem. Now, the second aspect, this registration is over. Registration is over. That arc is important. 5 facets. Vicious circle. You can't comply and you are making it impossible to comply. The second is this, my learned friend again gives much less than a half truth. He's again and again violating, or rather being Yudhishthir in his worst form. This a Muslim or professing the Muslim faith is a common phrase in any act which is religious focus. A Hindu may enter or a Christian may. That's the way it is used in the 23, 54, 95 and 2013. There is no act which says Muslim professing faith for 5 years and satisfy there is not a contrivance, reverse burden of proof. Not a single act. Act includes amendments. So it's a broad brush argument, it's always been there. It was there in 1913. It was there in 1923. So neither Musalman professing and practicing 5 years, the phrase absent. Second, contrivance is a reverse burden of proof. I must prove to him that I am not a contrivance, which is impossible. And to a collector who will make me go to his office for whole life. And then it links, as I said in the opening, which I am not repeating. I am the only faith which is asked to do this. That's an Article 15 point directly. 15 is being underestimated. The Lordship has got 25 and 26. 15 is overarching. And the first of the 6 grounds there is religion. First word in 15 is religion.
That is already argued in the main.
So, no other religion is asked to show a prophet practicing for 5 years or a contrivance reverse test. The Sharia was again a very misleading example. If I pass a Hindu Endowments Act, or if I pass a Sharia Act, the first sentence of all these acts in all religions, Christian, Hindu, Jain, will be a practicing Jain. So the Sharia Act says practicing Islam.
Right, Sharia.
Practicing Islam, it says.
Sorry.
And the conceptual difference, that's a choice I may make. I may make a choice to go under Sharia law or not. That choice is based on my practicing Islam. That has nothing to do with a Waqf Act where they've said practicing Muslim for 5 years at least and show a contrivance. No such provision is there. Next point, my time is very limited. Retrospectivity has been argued. Note it affects in 2 or 3 areas. 36(1) is completely retrospective for all times. The language of is seen. 36(1) is retrospective for all times. It says before or after, without time limit. Without time limit. And it then But at this point about 9 and 14, I find it very much odd, with great respect. My learned friend reads it as maximum. First argument is Manus, his benevolence cannot change the statute. You have no such maximum in that figure given at 2 Muslims and 3 Muslims for the council and the board. But what is more, Manus, the section has to be read only to add up. If the Lordship next to section writes the number is clear. It gives a figure. Now that has been done. I am saying, Manus, your Lordships cannot interpret this other than, Manus, in this manner. Just because he's countered at page 75, the whole argument is based on his counter. He says, I read it as not more than 2.
No, JPC.
That will not be correct. Then, Manus, 2 more things and I am done. Manus, the Bombay Trust Act, section 31, don't waste your time opening it, please note it, Manus, is nowhere near 36, 7A or 10.
Well, I read 31.
It is a 2-line provision. It has none of the barring effect of 3610 or 3670. That's a wrong example. Malus, JPC point given is misleading. JPC, Malus, my learned friend waxes eloquent in his counter on JPC. Malus, that JPC, it heard so much, it spent so much time. My lords have said, as a matter of law, I'm not arguing the facts, a very important thing is 11 dissenting notes, a lot of people not heard, those 2 clauses amendment did not come, that Lordship has heard already. But as a matter of law, my lords has, Malus, repeatedly said, and just note the citation to save time. Kalpana Mehta, 2018, 7 SCC, page 1.
2018.
Kalpana Mehta, 2018, 7 SCC, page 1.
Importance of JPC.
Para, thank you.
Both of us were there.
Para 440, no, we were not in Kalpana Mehta, we were in the matter which
I was in Kalpana. Yeah, anyway, sir.
Para 449.6. Para 449.6, followed Malus in the Delhi Assembly matter where we were both opposing each other. That was the matter. Then, Malus, this says, the quotation only, note this para, any observation in a report or inference of a parliamentary committee, that was an assembly, I think, cannot be held binding between the parties. But here it is worse, Malus. You had a huge number of suspended, 10 of the 31 members, no clause by clause discussion. 2 clauses came later. Keep that in mind. So JPC waxing eloquent is neither here nor there. Malus, Article 15 on both Malus, the example I gave, and in addition on 3E, exclusion. That's my submission. I can only add a note of comment. One last thing. Sorry, one last.
And the only
one last thing. No, one second. Well, I have not item. No, only 5 seconds. I forgot.
I remember Quran.
Let us listen to him.
No, well, 5 seconds. I forgot. Well, your Lordship is being asked for a stay. Just for item. Your Lordships can mold the relief. Your Lordships can accept some, accept, not accept. Just for itemizing the relief, we want, well, subject to my Lord's kind discretion, 3R deletion. 3R proviso. That's important listing. The Lordship will not have the focus. The focus is, no, that's the capital C. That's coming up. 3 small r deletion. 3 small
or proviso.
3 small r, the deletion itself.
Entire or only proviso?
No. That second, no. Deletion of the buck by user, that one line. I. 3R, then 3R proviso. Let me please finish, sir. I am
Detain your Lordship.
3R bracket I is the first. 3R proviso is the second. 3 capital C is the third. 3D and 3E are 4th and 5th.
4 and 9 and 14.
Then 9 and 14 are the council and the board.
108 immediately.
And 36 7A and 36 bracket 10. It's not arguing with 104 also, Lordship had. That's been also. I'm very deeply obliged.
My Lord, I am the only lawyer, my Lord, who has come from Jammu and Kashmir, Crown of India. Just 1 minute, I will. Your Lordship can see, because I read the entire Quran. The essential religious practice is in the Surah Baqarah. I have quoted your Lordship, not on my CMP. Your Lordship can go through it. 127 156.
What is the good name?
AM Abdul Majid Dar. AM Dar. AM Dar, sir.
AM
Dar. Your Lordship will see my CMP. 1257. 2 things are very important, my Lord. This is 1257 of 2025.
12?
1257, my Lord. It is 127156. 127156 is my CIP intervention. I was watching, my lord, all with my lord's permission. I will just demonstrate in 2 minutes how it is essential religious practice, my lord, in Islam.
Yeah.
Islam, my lord, the word waqf is derived from, it's an Arabic word. It's not an Urdu word. It's an Arabic word, wakufa. To detain, to tie up.
To hold.
To hold. Detain, that's what I'm saying. To hold.
To hold.
And the moment a Muslim, a believer, would, my lord, give a property as waqf, the Allah becomes the owner. That is already said. Now, my lord, may see the concept when it has come. Your lords may see para 5 in my application. Para 5, I read
It will
it.
take time, so it is better you read it.
Just I will read. I will
It
read.
will take time to find it out.
Just 1 minute, my lord. Just give me only 1 minute, my lord. I will read it. I read it, my lord. This is very important. That is why, otherwise, the result, my lord, travesty of justice, because I leave it to your lords with judicial wisdom. As far as the religious practice, I only want that. Because I remember the Quran verbatim, my lord. Your lords may see. I read it. My lord, particularly in the Islamic concept of waqf is not merely a legal or statutory device, but a spiritual act of perpetual charity that is called the sadqa jariyah. This is the one type of zakat, sadqa jariyah. Give it to the, my lord, the needy people. And this is a part of the zakat, which is the essential, my lord, foundation stone of the Islam. Then, para 6, that the term waqf is derived from the Arabic root waqafa, meaning to detain or to tie up or preserve. Historically, the institution of waqf was introduced by the Prophet himself in 622 Hijri. You will not note down it. 622 Hijri. After, my lord, he attained the Prophet. 622 Hijri. My lord, is very important. And well, this is very important. After he migrated from Makkah to Medina, it is submitted that Prophet, upon arrival in Medina, after migration, ordered his companion Sahiba to dedicate 11 orchards of dates, khajur ke, my lord, bags, dates, and trees for charitable purposes and pious endowments. This is when Prophet was gifted 11 orchards. After he attended the Prophethood in Medina, after he migrated from Makkah, my lord, he dedicated to the waqf. Waqf concept is from that. Now, my lord, we say, para 6, that the Prophet, my lord, peace be upon him, mandated the way of waqf to be given in a very secrecy manner. My lord, I see the term waqf. Now, my lord, we see para 15 and 16. Just 1 minute.
Yeah.
I leave it to you, lordship. Para 15, I read it. The creation of waqf is seen in Islamic theology as qarz-e hasba. This is another charity. Qarz-e hasba,
Yes.
para 16.
We'll read your application.
Yes, para 16. Just 1 minute, Malad.
Lord, may I just submit this data regarding those surveys?
Malad, another, only one submission, Malad. Your lordship read, only one submission. In state of Jammu and Kashmir, these all works that were not applicable to us. There was no registration. We were 3 acts. 1978 Act of Jammu and Kashmir, before application of Article 370.
May I just submit the data?
There was no registration, my lord.
Yes, 370 is not relevant in this.
No, there was no registration concept. Your lordship can appreciate. 3 acts were there. 1970 Act Waqf Act, 2001, and ultimately was there 2004. In all these 3 acts, my lord, there was no concept of registration. That is why in state of Jammu and Kashmir, majority of the Waqf property is there. And my lord, we appreciate, my lord, 1 minute. 1 second, my lord.
Thank you.
1 second, only 1 second. There are, my lord, shrines which are existing. Just only, I'm just winding up. Yeah, fine. My lord, I'm winding up.
But one sentence about
There are shrines. My lord, shrines.
Come on now.
Lord,
My lord, shrines are there.
one sentence.
Existing last 700 years.
Thank you.
Lord, one sentence about JPC alone, Lord.
Can I seek your lordship's indulgence of 5 minutes?
My lord, my learned friends have given up their right, my lord, to ensure, my lord, it would be unfair. It could really be unfair.
Yes, 5 minutes.
There's some wrong statements made.
Yes. But 5 minutes by the floor.
My data may be taken on record, not before Mr. Uzaifa starts, no, my data may be taken on record. This is data of 2019 petition. I'm sorry, my lord. No new facts can be taken.
There aren't any new facts.
Just see.
Anyway, we are not considering 2019, 1995 petitions that we have made it clear.
Is not required. New facts.
We have made it clear in the morning itself. Yes,
But for example, my lord, this.
We'll come to you later.
we have called upon Mr. Ahmadi.
Let him.
When we have called upon him, then we expect some respect to from both the sides to whatever we decide.
May it please, Your Lord. Just 2 aspects, my lords, which I want to highlight. I respectfully adopt, my lords, the submissions made by all my learned friends. And my lords, these sarcastic comments do not behold the high office that my learned friend occupies.
We are
That's
not
the
here
least
to
that I
advise
can
anyone.
Now,
You don't waste your half a minute on that, Raja.
no, I will not, Manoj. I will not. In any event, Manoj.
Don't carry your Ahmedabad things here.
No, it's all right.
No, there is nothing. You're never in Ahmedabad. But
everybody gets affected by Delhi atmosphere.
Yes. My learned friend is consistently incorrigible throughout the hearing, but let him maintain that.
You proceed with
Now,
that.
kindly see, Manoj, 6.
be prevented by the court. He may have a very personal, emotive issues with the old matter, but being indecent is not
just forget it.
acceptable.
Yes.
I can forget, but
Yes. So therefore, Manoj, I said whatever I had to say.
If
I won't address
you don't want to address us on the merits, we'll rise now.
I'll start with this.
We are not here to hear what you have to say about him and what he has to say about you.
Very well. Now, Manoj, kindly, Manoj, may I start with Manoj? I just want to make one short point with regard to section 3E, capital E. Manoj. Now, 3 aspects that your lordship may note. My learned friend gave the impression that in future, if any tribal wants to make a dedication, he can't make that in respect of a scheduled area. Now, point number 1, this does not only affect dedications in future, it also affects prior dedications which are made in the form of a waqf. So therefore, section 3 is retrospective, and any scheduled tribe Muslim who makes a dedication, that dedication will be void. Point number 1. Second, my learned friend said that this is meant for the protection of tribals. Far from that, my lords. The effect of section 3 is that it does not protect the right of, my lords, a scheduled caste or scheduled tribe, Muslim tribal, but its effect is to take away his rights under Article 25 and 26 to make a dedication. So therefore, far from protecting a right, it effectively takes away a right. Point number 3, Manoj. My learned friend said this is meant to protect tribals from illegal alienations because tribals by their character are vulnerable in those particular areas. My respectful submission is, Manoj, the Act does not, Manoj, prohibit transfer. So therefore, transfers can still take place. The effect.
There are other acts which take.
Maybe.
There are many
They may.
take care of.
I'm on the validity of 3D.
Prohibition as well as.
I'm on the validity of 3E, because what I'm saying is the effect of 3E is only this, that a Muslim tribal cannot create a waqf. Now, therefore, my lords, if the object was protection of tribals, and my learned friend said in the course of his submissions that this is only to protect tribals from illegal transfers. I am saying this does not protect tribals from illegal transfers at all. So that is not the object that is subserved by 3D, by 3E. The only object that is subserved is that a Muslim tribal is singled out in the sense that he cannot make a dedication as a waqf. So therefore, this directly impinges on Article 50.
Yes.
Now, interestingly, the learned Solicitor General, my lords, also said another thing. He said, what stops if he wants to make a dedication, he could make it in the form of a trust. That is what the learned Solicitor General said, Manoj. Then, Manoj, how are you protecting the tribal from any fraud? The fraud that you seek, according to him.
No, he did not make that argument with regard to 3. He made that argument with regard to deletion of Article 104.
So therefore, let me, Manoj, let me therefore deal with the provisions of the Act. The Act 3D, 3E does not prohibit a tribal from registering a trust if he wants. In the form of a waqf, because that's what the proviso to section 2 said that your lordships have already seen. Now, if that be so, then how are you subserving this particular object of protecting him? Well, I hope I'm being able to make myself clear. So all the submissions in defense of 3E, well, do not really muster or pass the test that my learned friend has sought to articulate. Now, fourth, and lastly, Malaj, and I'm done with Malaj 3, so far as 3E is concerned. Malaj, what is discrimination only on the ground of religion? Is there any similar provision in relation to any other member of the scheduled tribe where it is said that if, Malaj, a person who is a Christian or a Hindu belonging to scheduled tribe, if he makes an endowment, that will be void? Why, my lords, are you singling out only Waqfs? This is, my lords, discrimination.
This is already argued
only on one ground.
So
only on the ground of
Civil has argued it in the opening argument.
Now, second point, my lords, on limitation. I'll just be brief, 2 minutes. Now, the point on limitation that was made is that so far as limitation is concerned, under section 107 and read with 108, it applies equally to both sides. This is factually wrong. Kindly see, my lords. First, if your lordship would be pleased to have section 6. If there is a challenge of the 2025 Act, my lords.
Yeah. Yes, section 6.
Yeah.
Yes, we have.
If your lordship sees, my lords, subsection 1 of section 6, the title is Disputes Regarding AUGUSTINE. Now I'll leave subsection 1 out. Kindly see the proviso. Provided that no such suit shall be entertained by the tribunal after the expiry of 2 years from the date of publication of the list of AUGUSTINE. So there is a limitation of 2 years if you want to challenge the declaration of a particular property as a Waqf. Now, under the second proviso, what it says is, provided further that an application may be entertained by the tribunal after the period of 2 years specified in the first proviso, if the applicant satisfies the tribunal that he has sufficient cause for not making the application within such period. So, a challenge to a declaration of a particular property as a Waqf is left open-ended. It is 2 years plus make out sufficient cause. But so far as, my lords, other properties are concerned, including evacuee properties, 107 and 108. Now kindly see the effect. On and from 107, your lordships would be pleased to have.
Please.
On and from the commencement of the Waqf Amendment Act 2005, 25, the Limitation Act 1963 shall apply to any proceeding in relation to any claim or interest pertaining to immovable property comprised in a Waqf. So, my lords, limitation under 107 is absolute. There's no sufficient cause. Now kindly see the effect on evacuee properties. 108, special provision relating to evacuee Waqf properties omitted. Now what is the effect? The declarations for evacuee property are age old, 1950 to 1960. What happens on a declaration as evacuee property? The property vests in the custodian. Now today, my lords, earlier, evacuee properties were protected by the old 108.
Yes.
Today, if I want to challenge a declaration of evacuee property made in 1955, because my reason to challenge the declaration only arises now. Earlier, I was exempt. That will be hit, my lords, by section 107. So I will have no remedy because evacuee properties were protected till the act came into force. I will have no remedy at all. That's what I have to say, my lords, on limited.
Are you appearing on behalf of any person who is claiming an evacuation property.
No, in my matter, my lords, in my matter, my lords, but we have several other matters raised this point. I can point out from the pleadings. And my lords, we take this essentially as a class action. But be that as it may, we would be beneficiaries also as Muslims of evacuating Waqf properties. Now, last point, my lords, just one point. Sorry, my lords. I beg your pardon, my lords. 1,000 apologies and 1,000 pardons. Now, my lords, kindly see, my lords, the last aspect with regard to section 2 and the proviso. The portion, my lords, which relates to a trust. Just, if I may just show that provision.
Yes.
Section 2, my lords, proviso. Where is that proviso?
Proviso is that nothing shall.
Yes, my lords. Provided that, sorry, my lords, I've lost it in this. Where is the proviso? Just show us.
Provided.
Yes, I'm so sorry, my lords.
Second proviso.
Second proviso.
Provided further that.
Yes. Provided further that nothing in this act shall, notwithstanding any judgment, decree, or order of any court, apply to a trust by whatever name called, established before the commencement of this act, or statutorily regulated by any statutory provision pertaining to public charities by a Muslim for purpose similar to a waqf under any law for the time being in force. So therefore,
yes,
the dedication, even in the form of a waqf, according to my learned friend, can be registered in the form of a trust. If you register it in the form of a trust by virtue of this proviso, you will not be subjected to the rigors of the act. That is to say, you don't have to show that you're a practicing Muslim for a period of 5 years, etc., etc. Now, what is the object of the Waqf Act? The object of the Waqf Act is, my lords, not to discourage registration of waqfs. You are effectively, my lords, telling every Muslim by virtue of this proviso.
Go and register a trust.
Sorry, my lords.
Go and register a trust.
Go and register a trust. If you register a waqf.
I was only anticipating what is the argument.
Yes. If you register a waqf, you will be subjected to all these rigors.
And if you
register
a public trust, you will not.
And you will not be. So the whole idea is to discourage registration.
Thank you.
And not to encourage. My lords, I thank your lordship for your lordship's kindness, my lords. I'm extremely grateful.
All of us do.
Dr. Singhvi, now you will be responsible at least for one week of both of us in a partial working week. In court number 2 and court number.
Should continue this.
Yes.
Yeah, of course. Lordship may expressly say it.
Of course, man.
Yes.
It's a village which has been taken over by Waqf from
Exclusive village, declared as Waqf, under section 40, which is now deleted.
Chendurai village, my lord.
Entire village is declared a Waqf.
And there is also a temple which is 1,500.
Later.
Yes.
There is a temple, my lords, which is 1,500 years old.
You are
which
from
was built,
Telangana?
from Tamil Nadu, my lord. And there was a temple which is 1,500 years old, my lords, which was built by Aditya Cholan. And the Islam by practice itself is 1,400 years old, my lords. The entire village called Tiruchendurai is being taken over, and I really wish my lords take this also in record that there are a lot of villages which is.
May I make